Looks like we're on the record. So we'll kick it off and establish quorum then and do roll call. Jeff Morris.
Here.
Randy Lowe.
Here.
John Thorpe.
Here.
Ronnie Collier.
Here.
Adam Lewis. Looks like we have quorum chair. If we may we move to the notice of meeting? We'll do so. It's a notice of the May 20th, 2019 meeting of the Auctioneer Commission was posted to the website on May 13th, 2019. Looks like the next item there is the agenda. Does that look like that will work for everyone? Is there any edits or any comments?
No, I move we adopt the agenda as written.
Second. Motion's been made and seconded to adopt the agenda as written. All in favor say aye.
Aye.
Any opposed? Next item, the minutes. Anybody see any corrections or additions?
I move that we adopt the minutes as written, sir, Mr. Chairman.
Second.
Motion's been made and seconded to adopt the minutes from previous meeting. Any discussion? All in favor say aye.
Aye.
Any opposed? No. Director's report.
If you recall, at our last meeting, we did a deep dive and we looked at the last 2 fiscal years to include the Education and Recovery Fund, the General Fund, looked at the trend analysis, did all those comparatives. So we'll focus on the last 3 months, since that's the only thing we haven't covered. You'll notice that there was a reallocation of legal costs that gave us a spike on November and December. Which resulted in noticeable increase in operations. I looked at January through March, looking for anything outside the ordinary, and I saw another spike, it looked like, in February. So upon following upon that, I realized that there was a lot of litigation work to clear some old cases, to include the formal that the attorneys were working on at the time. So that's where those costs are coming from. Now, if we see another one like that, I think those are pretty well cleared. If we see another one like that, then we'll kind of push back a little bit and unpack that a little further. But right now, it looks like it was the litigation work. We've had some litigation attorneys piling on that one. So anyway, I think we're in good stead right now. I didn't see anything else outside the ordinary. This is just for informational purpose. So obviously, if you have any questions about that, I'll entertain those. But other than that, it looks like we're running for a net surplus. Total year of right now about 6,000 is what we're tracking at.
Any action on this? Just
No, sir. That was just informational purposes. So unless there's any questions, we'll move on to the education review. Of course, we're familiar with this provider. We've had them before. They have their seminars or their conferences pretty regularly. I trust everyone's had an opportunity to look at that.
This is for like on a Monday after the TAA.
Right.
Summer.
Yes, sir. Mm-hmm.
I'll make a motion. Second.
Motion's been made and seconded to approve the continuing education. Any discussion? All in favor say aye.
Aye.
Any opposed? No.
We'll move on to the instructor review then. This is our alcohol, tobacco, and firearms course put on by the ATF. I think they're one of their investigators and instructors is retiring, and then an investigator who's been there for quite some time, a senior investigator there as well, will be taking his place. His qualifications are stated in his CV. If it's in the opinion of the board that he would qualify as an instructor to aptly run that course, then we'll just need a motion in that regard per Rule 163.4, which states the program is conducted by instructor, discussion leader, or lecturer qualified in the opinion of the commission by either education or experience or both. So in your opinion, if you believe he would be qualified to teach an ATF course based on that CV, then we'll just need a motion in that regard.
Is the applicant William Gallivan or John Bobbage?
John Bobbage.
John Bobbage, okay.
Mhm.
I see, okay.
Motion's been made to approve John Bobbage, education instructor. Is there a second?
Second.
Second by Mr. Collier. Any further discussion? All in favor say aye.
Aye.
Any opposed? No. Newsletter.
All right. We've already had one newsletter behind us, so this is, obviously, we have a biannual newsletter. Newsline is the namesake on that. And if I can get my iPad to work. Oh, there we go. All right, whew. Everybody else doing okay?
Yep.
Okay. Got a little bit of delay there.
Yep, got it.
Okay, so this is our newsline, much in the frame of what we've already approved in the past. We just need a review by the board, and if there's any comments or any edits that they would like to make or anything additional that they would like included. One thing of note is the second item, and we're going to get to that, but the legislative updates, we're going to be talking about some of that, but they've highlighted some of those there. And of course, the last page, after we take action on this one way or the other, you'll want to stay on that last page because we're going to look at the continuing education seminars and look at those dates and see if that's fine with everybody. That'll be the next item.
See in Middle Tennessee.
As for the topics and the newsletter itself, will that suffice? Would that please the commission?
Looks good to me.
We would. Mhm.
Make a motion to approve.
Second.
Motion been made and seconded to approve the newsletter. Any further discussion? All in favor say aye.
All right, that last page of the newsletter, they've got their CE seminars coming up, and I'll actually be going to their West Tennessee one for this past year. This is for the upcoming year, and we're just my purpose today will just be to educate them on some of the benefits of online onboarding. Eventually, all of our applications will go there. Right now, it's just the renewals, but we'd like to expand that for just efficiency's sake. So just to kind of introduce that topic, but then also to discuss some of the legislative updates that we'll discuss after this as well. But these are the dates for the upcoming year. Does this look like this will suffice thus far, at least the next couple dates? It doesn't have the entire year, but looks like we have.
September and March, is that the next two dates? Is that what I'm reading right?
Yes, sir.
Every 6 months, is that what we're doing?
They do 3 a year, one in
Okay.
each grand division. Mhm.
Everybody good with it?
Yep.
You need a formal motion to approve those? Okay.
I make a motion that we approve.
Second.
Second.
Motion been made and seconded. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. Legal report.
Good morning, gentlemen. My name is Denard Mickens. I'm the chief counsel for Reg Boards, and so it's a pleasure to be here this morning. Just as a housekeeping matter, the attorney that you had met at the last meeting, Keith McCarthy, he's no longer with the department. He moved on to other opportunities.
We're used to that.
And so I'm going to be filling in today. I'm not sure. We're always keeping an eye out for good new attorneys.
We're gonna miss all the JAG demeanor. I mean,
Yes, sir. That's right. And so he will be missed, but we're going to try to find some new attorneys. So that's in the process, and so we'll be looking to try to find a permanent replacement shortly. But today I'm here to join in the fun. So we've got 2 entries for the legal report. I think Anna went ahead and handed out those updates, and so one is a represent. And one is a new case, so we'll just go ahead and start with the new case. So that is complaint number 2019-005221. Just make sure everybody's got that one. So Basically, this complaint, the complainant purchased a gumball machine during an online auction. Although pictures of the item were posted, there was no description beyond a Maravin tabletop gumball machine measurement, and gave the numbers. When the complainant received the item, they discovered it was made of plastic, and they were very unhappy. The complainant contacted the auctioneer and was told, "What you buy is what you get." The complainant is unhappy that there was no opportunity during the online auction to ask questions about the item, and the complainant feels that the auctioneer misrepresented the item and failed to disclose an honest description. The respondent replied that all items were listed online for 12 to 14 days prior to the auction and were available to view in person. Additionally, the auction house's phone and email were posted so that customers could ask questions. Although the auctioneer is not available to answer questions during the auction, staff on site can answer phone calls and questions. There was no record of the complainant inquiring about the item. And finally, the respondent sent a copy of their policy, which is on the next page, which just says, respondent will always describe all lots to the best of our ability. However, respondent makes no claim as to the provenance or authenticity of any lot. All lots sold as is, where is, absolutely no warranty, either expressed or implied. In the complainant's rebuttal, they state that this policy is posted at the auction house and not available to the online bidder. The complainant also reiterates that they feel the item was not accurately described. Counsel believes that the complainant had multiple opportunities to ask questions about the item before purchasing it. Additionally, counsel believes it is incumbent upon the purchaser to ask those questions before buying. So the recommendation of legal was to dismiss.
Move that we dismiss this case.
Second.
Motion's been made and seconded to dismiss the case, accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed, no. It's dismissed.
And the last item on the legal report is complaint number 2017-074811. And this was an older case that was being brought back for your review. And so the original write-up had that the complainant stated that they participated in an online auction held by a respondent to purchase land adjoining land that the complainant owns. During the last few hours of the auction, the complainant noticed another bidder who began to rapidly bid on the same parcels and rapidly bid up the price, but did not appear to be attempting to place a winning bid. After a considerable amount of research, the complainant alleges they determined that the bidder had an extremely high probability of being employed by the respondent and engaging in shill bidding. The complainant states the rules of this particular auction clearly stated the owner is contractually prohibited from bidding on his or her own property in this auction. The complainant provided a list of usernames and bids made during the auction. Counsel requested an investigator obtain the real names of the bidders listed in the document, but respondent refused to provide this information, stating that this auction is not regulated pursuant to 2006 exemption and subsequent legislation. Counsel at that time agreed that with the respondent's argument and found that the auction is not subject to the jurisdiction of the Auctioneer Commission. At that time, the recommendation was to dismiss, and the commission voted to accept counsel's recommendation. So the new information that we received, it says that the complainant submitted additional documentation for the property and respondent and their employees alleging potential misconduct. Complainant provided information of potential bidders with names and accompanying usernames. However, complainant provided no evidence other than summaries of alleged conversations with the respondent that these usernames actually match the identities of the real names provided. This matter was sent for investigation. The investigator visited the site and spoke to the respondent. The respondent stated that online extended auctions were not regulated, as they had said before. Respondent provided complainant a letter stating, "I realize you have issues with your bidding and purchases in our auction, which we concluded on that date. I am willing to discuss your concerns and work to resolve your issues. I want to bring this matter to a satisfactory conclusion and make right any problems you may have." Council notes that TCA 62-19-1039 states that any fixed price or timed listings that allow bidding on an internet website but do not constitute a simulcast of a live auction is exempted from the provisions of the chapter. Subsequently, the rules state, pursuant to that same statute, time listings do not include listings that are extended or those in which the bidder has an opportunity to increase a bid, etc. Nevertheless, council believes it is important to remind respondent of certain prohibited activities. Therefore, council in this case recommends a letter of instruction to respondent informing respondent of the prohibitions listed in TCA 62-19-112, paragraphs 10, 11, and 12.
What's the will of the commission?
Diana, this one you want me to recuse myself on? Okay. I'm
I make a motion to go with the legal advice.
Motion's been made to concur with legal's recommendation, issue a letter of instruction advising respondent to remain mindful of the prohibited acts listed in TCA. Is there a second to that?
Second.
Seconded. Any further discussion? All in favor say aye.
Aye.
Any opposed? Any abstention?
one.
One abstention. Let the record show us 3 yes, 1 abstention. All right.
All right, thank you.
Legislative updates.
Okay, so we're gonna have a two-part, and unfortunately, it's gonna be a lot of me talking to you. But the first part, we're gonna have to follow along with you. As you all know, we the auctioneer statutes are being have been amended, and as of last week, it had been signed by the House, the Speaker of the House, and the Speaker of Senate. Now we're just awaiting the governor's approval, and so for him to sign it. And so if and when the governor signs the bills, we will send you a copy of the public chapter that gives you that so you can see the new laws and statutes. We just do not have that at the moment. So what I've provided before you is a summary of the changes that are going to occur within the statute. So we'll just go through those briefly.
Just a quick question.
Sure.
What do you think the timing of this is going to be if the governor signs?
I believe when we did a bill analysis that the statute will go into effect July 1, 2019. Yes, of this year. We can talk some more about fees regarding the new licenses in a second, but I just want to give you a brief update of the changes. So with number 1, we have that the bill is going to revise the governing time of a sale in regard to judicial and trust sales. So it revises the provision from previously stating that they have to be from 9 to 7, that the published ending times must be between the hours of 9 and 7 of the day fixed in noticed or advertisement. So this one is kind of basically includes internet bidding platform in the definition of the fixed sales. Number 2 is also accompanies the judicial and trust sales provisions. It states previously that whenever real property is sold at a public sale conducted by an auctioneer, it must be conducted on the premises of the real property to be sold, and it does not apply sales of real property for delinquent property taxes. The amendment to the bill would instead provide that whenever real property is sold at a public sale conducted by an auctioneer, the manner and method of the sale is at the discretion of the court. And it amends the definition of public sale as auctions on internet-based bidding platforms, in-person, on-site, or off-site auctions, and other accepted auction methods, so long as the auctions are open for participation by the public at large. Also, it allows the court to impose additional conditions or procedures upon the sale of property as are reasonably necessary. Number 3, it addresses motor vehicles. So when a motor vehicle is sold incidentally at a bona fide going out of business sale, A license as a motor vehicle dealer is not required to sell the vehicles at auction if all vehicles for sale were owned and titled in the name of the business for at least 1 year prior to the going out of business sale, and the auctioneer gives a 14-day prior written notification to the Motor Vehicle Commission, providing the time and place of the sale and the items to be sold, and that it applies with our Tennessee Consumer Protection Act. Number 4 is going to give you the differences in terminology. So in the statute, we are going to be going from affiliate auctioneers instead of apprentice auctioneers. Also, it combines the definition of auctioneer and principal auctioneer, and we're going to have an additional category of a bid caller auctioneer. A bid caller auctioneer is defined as an individual who, for compensation or valuable consideration or otherwise, is hired by a principal auctioneer, public automobile auction, or public automobile auctioneer to solicit bids for the purchase of goods at an auction. Also, it removes the definition in references to a firm in the statute. So, number 5, under present law, it's unlawful for a person to act as or to advertise or represent to be an auctioneer, apprentice, auctioneer, or firm without holding a valid license. This amendment removes apprentice, auctioneer, and firm from this provision. So present law provides that all auctions arranged by or through a firm must be conducted exclusively by individuals who are licensed as auctioneers. So this new change is going to require that all auctions be arranged by or through a principal auctioneer and must be conducted exclusively by licensed individuals. Number 6, the present law exempts laws governing auctioneers as an auctioneer conducting a sale of tobacco at or for a warehouse. This revises the exemption to instead exempt an auction sale of tobacco at or for a warehouse. It also includes 3 additional exemptions. A, an exclusive online auction whose primary business activity is selling non-repairable or salvageable vehicles in this state and holds an appropriate license issued by the Tennessee Motor Vehicle Commission. B, an in-person or simulcast auction whose primary business activity is selling non-repairable or salvage vehicles in this state and holds the appropriate license issued by the Tennessee Motor Vehicle Commission, and that used a licensed auction, and an individual that generates less than, I believe this number has changed from 10,000. I'll get back to you. I think it's gone actually up a little bit in a calendar year from the sale of property in online auction. So we have, that's what I thought. The new number is 25,000, not 10. This is older. So number 7 is the amendment also exempts an auctioneer from the present law continuing education requirements if the auctioneer only holds a bid caller license. So bid callers, auctioneers do not have to do CE. The requirements for a bid caller auctioneer would be at least 18 years of age, successful completion of 16 hours of classroom or online instruction on the basic fundamentals of auctioneering at an auction school accredited by the commission. Auction chant instruction is optional and will not be included in the basic fundamentals of auctioneering, and auction chant instruction may not be completed online. Number 9 revises the requirements for licensure as an apprentice, which is now an affiliate. So this revises the provision to state that you, instead of successfully completing 80 hours of classroom instruction and fundamentals of auctioneering at an auction school, now it requires the applicant to successfully complete, in addition to the 16-hour basic fundamental instruction described above, 34 hours of classroom, online instruction, and fundamentals of auctioneering. So it reduces it from 80 to the 34 and 16. Also, the amendment, number 10, the amendment decreases from 2 years to 6 months, the time for which an applicant for an auctioneer must have served as former apprentice but now affiliate auctioneer. Also, the amendment number 11 revises the instruction requirements for applicants for a public automobile auctioneer license. Under the present law, in addition to the 80 hours of instruction required for an apprentice, the applicant must have completed 30 hours of more rigorous classroom instruction. So now the applicant must have completed, in addition to the 34 hours described for above, 15 more hours of more rigorous classroom or online instruction. Number 12, the amendment adds that an individual who receives a public automobile auctioneer license may exercise all activities authorized under a principal auctioneer license or bid caller license without having to meet additional licensure requirements. Number 13, this amendment adds to the provision whereby a license may be suspended, revoked, or refused if the individual makes a substantial representation that will be considered a material misrepresentation. Then an individual licensed solely as a bid caller auctioneer holds out to others as being a principal auctioneer or public automobile auctioneer. It also adds as a ground for licensure, suspension, revocation, or denial, the act of negotiating or executing an auction contract to sell goods, take possession of seller assets, or take possession of auction proceeds as a bid caller auctioneer. Number 14, this amendment provides that a principal auctioneer may sponsor an affiliate auctioneer after 1 year of licensure. Under this amendment, there is no limit as to how many affiliate auctioneers a principal auctioneer, public automobile auctioneer may sponsor. And number 15, the amendment authorizes a public automobile auction to hire a licensed auctioneer to solicit bids at the auction. And at the very bottom, you'll see the change that we noted before, that online internet-based bidding has increased from $10,000 to $25,000, the amount that must be generated for the exemption from the auction laws. Does anyone have any questions?
The one question I have is, and one of the things we did talk about, I was on the task force, is to really hone down on the definition of what an online auction is. Did they talk about that at all? Is that more clearly defined in that legislation? Because it was a little fuzzy the way the law is written now, and we really try to tighten that down with the legislation that we tried to present to the legislature.
Yes, that is also amended.
The main thing here we're trying to go make it more simple. We were trying to make it an ease of access into the business. Basically, you have 3 levels of licensing. You have the public automobile auctioneer, the principal auctioneer, and the affiliate auctioneer, and then you have the bid caller. And that just makes it a lot easier for these guys that all they want to do is call bids. They can get in with 16 hours and do it online and that sort of thing. So it makes it easy for those guys. And it also makes it easier for our affiliate auctioneers now to get from affiliate to become a principal auctioneer. I think they did a good job in trying to make it easier. I know that I'm getting calls from other states wanting to know what we're doing here so they can kind of piggyback on what we've done already. Mississippi comes to mind. I don't know what to send them. I can send them, this, but I think that they're looking for ways to make it a lot better for them as well.
I had a similar conversation with Alabama. They're doing the same. Changed, so. All right, any other discussion on it?
Do you think this will go into effect July 1?
Yes, I believe it will go into effect July 1. So with that, we're obviously going to have to do a lot of rule changes. So expect in the August meeting having a lot of rule proposals brought before you. One thing we would like to note is because based on a state law regarding fee structures, so we have added a new license for bid caller auctioneers. The state law states that if the fees are not already delineated in the statute and are not implemented prior to April of that year, that the fee structure cannot go into effect until the following year. So what likely is going to happen is we will be able to license the bid caller auctioneers, but we won't be able to collect said fees until July 1st, 2020. So we'll have some issues there, but this has happened before in other programs, so it's not something that is new, but we'll bring before you rules and proposed fees for those rules. All of those things hopefully will get a start on it in at the August meeting. Anything that's left lingering behind and address in November. So we're going to have a lot of fun talking about rules.
So will those just use the same fees we have now if
So-
you issue?
I think everyone else. I don't believe we're going to amend the fees for the other licenses. We will have to set a fee for bid caller auctioneers, which will probably be comparable in the same arena as everyone else. But I'm not going to speak to that because we don't know yet. Also, one thing that I forgot to mention is that with these statute changes, as you know, we no longer have the firm license, and also the gallery license will be removed as well from that, from the statute. So we'll be having some removals and one addition to that and some education changes. So we'll have to.
So will we have kind of a deep dive into the rules, each one of them, and kind of go through and modify and change and delete and add, or how does that going to work?
Yeah, so that seems like it's going to be my summer project, is going through the rules and looking at all of the rules that we have. And since they're based on the previous statute, we'll be either probably amending rules. There's a possibility that we'll have new rules and repeal of rules. Most likely we'll be repealing any rules that go towards the firm license since that will no longer exist. Gallery license, those rules will be repealed as well. So it'll be a combination of repeals, amendments, and new rules.
So what's the process if we come up with a new set of rules that we want to adopt?
Yeah, so
And so the commission votes on that?
right, so I'll talk to Glenn and Roxana and Denard, and we'll try and come up with some new rule language, and then we'll present it to you, and then you can amend and change whatever you would like. So nothing will be changed without the consent of the commission. So,
Once we adopt them, when do they go into effect?
okay, so that is a completely different story. So the rule making changes, now that the executive order has been lifted, I don't see any of our rules going into effect until 2020, most likely based on the rulemaking. Because it takes a few months to get internal justification, Attorney General approval, Secretary of State. There's a whole bunch of different changes that we'll go through. So we're gonna try and get them done as soon as possible, but it'll take some time.
That's why that next meeting will be really important, because when we'll start with the red line is what you were asking, and then build off of that, because we want to leave there with a set of rules, because the clock starts from then, and then you're looking at about 9 months. So 9 months from our next meeting, you're looking at May of next year.
But if there's anything we can do to help in this process, even between meetings or whatever, if it's possible, we'd love to. I mean, I'm available to do that, so.
Well, and then I can reach out to each one of you folks individually. You've been great as far as responding to us, and I appreciate that. And I imagine if we get to one of those kind of weird places where you're not sure what to do with it, then I'll kick that out to everyone, and then individually, obviously, we'll blind copy so that way we're not in violation of the Sunshine Law.
Okay.
And then we'll have that discussion then.
Right, so So we'll do the best that we can on the legal side, but if there's something that we're missing because you guys are the subject matter experts, I will definitely be relying on your help for that if there's something that I have missed or...
I think each of us are happy to do that, so.
Okay, fantastic. Are there any other questions about the statute changes?
I'll just say, I don't think there's much that you miss.
Well, I'm quite happy that it happened in one session. I figured it'd take 2 or 3 years before it ever matriculated down, but apparently it didn't, so I'm happy about that.
So as I said before, once we get the public chapter information, and we'll send that to you in an email, so you'll have that provided for you, and then it'll also be changed as well. So the next thing that we're going to do is, I don't have a handout for you, but we're required to give an update on the open records and public meetings statutes that we're all governed under. So I have a PowerPoint, not here. It's in front of me, so afterwards I'm going to email it to Glenn so you guys will have it for your own keepsake. We're going through this with all of our boards and commissions. It's just a quick refresher of these statutes, and then the conflict of interest statute. So as we know, for example, today our conflict of interest statute, the standard that you're looking for is whether you are able to be impartial. So if you believe that if, for example, if there is a legal report entry that's presented before you, the facts may look similar to you if you've seen them before, it would be appropriate in that instance to recuse yourself. However, cannot force you to recuse yourself, but if I know of something in advance, I will come to you before the meeting and say, hey, you may want to recuse yourself from this number. And so when you recuse yourself from a particular entry in the legal report, it is appropriate to not participate in any of the discussion or the voting. And then just at the end, you'll say that you'll abstain. So it's all about whether you believe that you can be impartial. So even if I think it's sometimes difficult because you have a smaller industry, so you may know more individuals as opposed to the Real Estate Commission, for example, has 32,000 licensees. It's a little bit more difficult to differentiate yourself. So if you believe that even if you may know, you shouldn't know because it's anonymously presented, but if you don't feel comfortable and do not feel like you're impartial, it's okay to recuse yourself from that. You don't have to tell me beforehand. If you're going to recuse yourself, you can just do it during the vote. But just remember, a recusal also removes yourself from all kinds from discussion and deliberation. So as you know, we have an Open Records Act, and the Open Records Act, this is for when we have public records requests and those type of things. So we're allowed, Tennessee citizens are allowed to request certain records, and those are made available to them. So a public record or a state record means all documents, papers, letters, maps, books, photographs, microfilms, electronic data, processing files, output films, sound recordings, or other material, regardless of physical form or characteristics, made or received pursuant to law or ordinance in the connection with the transaction of official government business by any governmental agency. So anything that we are that's done in the process of business is considered a public record. For example, our legal reports are public record. The complaint files that we receive, most of it is considered public record. Certain emails are considered public record, licensee information, but for some exemptions are considered public records. So keep that in mind, that more likely than not, a document or an item is going to be a public record, but there are some exemptions. And when we fill those requests, obviously, we take those into effect. Auctioneers, we don't receive too many public records requests, but some boards receive them quite frequently, up to 3, 4, 5 public records requests a week. So that's an avenue that some individuals use. Next, we have the Public Meetings Act, which is codified in TCA 844, Title 8, Chapter 44, Section 101 further. So the Public Meetings Act defines what a meeting is, what is required for a meeting covered, and what happens if a board violates the Public Meetings Act. So the general TCA 844-101A states the General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business shall not be conducted in secret. This shall not be construed to limit any of the rights and privileges contained in Article 1, Section 19 of the Constitution of Tennessee. So this act is remedial in nature and should therefore be construed broadly to promote openness and accountability in government and to protect the public against closed-door meetings at every stage of the government body's deliberation. So in application, that means that all meetings of any governing body are declared to be public meetings, open to the public at all times, except as provided by the Constitution of Tennessee. So the governing body, which would be your commission, it's the members of any public body which consists of 2 or more members with the authority to make decisions for or recommendations to a public body on policy administration. The Public Meeting Act applies to every meeting of the board or commission. So that means a meeting is defined as the convening of a governing body of a public body for which a quorum is required in order to make a decision to deliberate toward decision on any matter. Thus, committee and subcommittee meetings are included. We don't have those, but if they were, they would be included on this. So what is not a meeting? So a meeting does not include any on-site inspection of any project or program. Also, it does not include a chance meeting of 2 or more members of a public body. However, no such chance meetings or informal assemblages can be used to decide or deliberate public business in circumvention of the spirit or requirements of the Act. So that means that 2 of you could share a meal together in which public business is conducted, but the discussion should not constitute deliberations, which means examining and consulting in order to form an opinion, weighted arguments for and against a proposed course of action. Also, lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, adjournments between 2-day meetings of a multi-meeting, and all of those items when board business should not be discussed. So if you happen to run into each other, I don't know, at Target or somewhere, and you're just like, hey, what's up? That's not a public meeting unless you're like, hey, let's talk about complaint number 2020, blah, 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 blah. That would be a public meeting and in violation of the Act. So that is a terrible example. But basically, you know what I mean by that.
I can imagine it. It was it's just so surreal. I felt like I was there.
Regular meetings and special meetings count as meetings, and all are subject to the Public Meetings Act. The only exception is executive session. Have you all ever had executive session before? Okay. So an executive session occurs when 1 or more members meet with the board's attorney and the board is under threat of lawsuit or has been threatened with suit, and the members ask their attorney questions related to such a suit. So during an executive session, for example, it would be only the board members, myself, Glenn, possibly Denard, would not be filmed. It would be here. We would talk about specific if you were going to be sued or those kind of things. So executive session doesn't happen very often. I've only had one while I've been an attorney here, and so that was only when there was a threat of lawsuit. So we just wanted to give commission members the abilities to ask any questions, what they should or should not do, and those kind of things. But during those times, it's mainly you asking questions about it. So you are not to deliberate about any specific matter before or potentially before it in any executive session. So there was one particular case that wanted to see how far it goes. So it stated that oral interviews conducted by the Civil Service Commission of Maury County with persons applying for jobs within the classified service of the Maury County Sheriff's Department do come within the provisions of the Open Meetings Act. So executive sessions don't happen often, but if they were to occur, we would let you know before email and try and coordinate said executive session prior to a meeting or directly following a meeting. Does anyone have any questions thus far? No? Okay, we'll keep going. Electronic communications. So, if a member emails the chair and says, here's a news article, I'd like something included on the next agenda, not here's a news item about one or our licensees we should consider revocation. So, the first two instances would not be considered information for the Public Meetings Act, but you should not say, oh, here's a news article, we need to do something about it. That you shouldn't do that. Okay. If a member emails the Commission's counsel and says, I have a question about the legal consequences of something the Commission has done, that's permissible. Not, I have taken an action as a commissioner and now someone is upset. So that whole ask, what is it? I don't know how the phrase goes. Ask for permission later? No.
Easier to give for forgiveness than permission.
Yeah, let's not do that. That's the one. Not here. Not in those instances. If you ever have a question, please call me. Please email me, because the last thing we want is something like that to have any negative impacts. So if a member emails another commissioner and says, if you send an email or pick up the phone to call another commissioner, that is not a chance meeting. So you are deliberately calling another person. So even if you don't discuss commission business, it gives a strong appearance of impropriety, and for safety's sake, it should not be avoided. It should be avoided. Electronic attendance. So what if one or more members cannot attend the meeting in person? The absent member may participate telephonically, but all votes must be roll call votes. That is so the public can know how any given commissioner voted on each issue. What if one or more members cannot attend a meeting in person? If those members present in person make a quorum, the meeting may proceed as normal with the other members participating by phone. But if the in-person members cannot make quorum, then the board must adopt and promulgate a statement of necessity. Then the meetings can go forward. So if there was an issue like that, we had to do an emergency telephonic meeting, we can definitely set those. We'd have to provide notice, but then I would draft a statement of necessity and read it into the record, and then that would be filed with the Secretary of State's office. Those only come when there's something that is absolutely pertinent that occurs in between meeting sessions. So in case that happens, we would obviously let you know plenty of time and coordinate conference call or something of the sort. The act is to be construed most favorably to the public and is all-encompassing and applies to every meeting of a governing body except where the statute on its face excludes its application. So, for example, the public has the right to attend and observe your meetings, but not required to participate. You are not required to let just anyone speak. So, technically, if someone were to come to our meeting, they can they're more than welcome to attend, but it is up to your discretion whether or not you would like for them to speak or not. So don't feel obligated if someone comes to allow them to speak at the meeting. Notice. As the standard for notice is a three-pronged test for adequate public notice. 1, the content of the notice must be reasonably describe the purpose of the meeting or the proposed action to be taken. 2, notice must be posted at a time sufficiently in advance of the actual meeting in order to give citizens both an opportunity to become aware and to attend the meeting. And 3, notice must be posted in a location where a member of the community could become aware of such notice. So all of our notices are posted online on our website. So once you receive an email from Glenn, then that notice is posted online, where the public meetings is the section on the Auctioneers Commission, and then that is usually typically, I believe, about 3 or 4 business days.
It is, but we usually try to do it about a week out, but you're right.
Or a week out. Look, even better. The public notice discusses the adequacy of various media for advertising the notice when trying to meet the location of notice requirement. As I stated, our usual practice is to publish on the website. So here are the penalties that come from the Public Meetings Act. The legal effect of anything that violates it is nullity. Practical impact are substantial costs and assessed against annual operating budget. So anything that is conducted that is not in a public meeting session will not, it is null and void. So it's not going to any kind of effect. And there are other possible ramifications that could come from that. So we just try to do, as we said, everything in a public meeting, which we shouldn't have a problem doing. So in a nutshell, the Public Meetings Act is designed to make sure all board business is conducted in a way accessible to the public. It applies to you both as an individual member and collectively as a board. So if you violate the law, any violative acts are void, and costs of litigation may be assessed against the board. I have one more section here. It's about North Carolina dental examiners versus the FTC. So are you all familiar with this? Okay, so we are familiar, but we'll still go over it real quick. The North Carolina State Board of Dental Examiners issued 47 cease and desist orders to non-dentists about teeth whitening. In response, the FTC filed a complaint alleging the board violated antitrust laws by unilaterally ordering non-dentists to stop providing whitening services. The board argued state action immunity. The FTC ultimately prevailed at the U.S. Supreme Court. The Supreme Court rejected the board's state immunity defense because the board did not receive active supervision by the state when it interpreted the act as addressing teeth whitening and when it enforced that policy, issuing cease and desist orders to non-dentist whiteners. State agencies are not simply, by their governmental character, sovereign actors for purposes of state action immunity. Immunity for state agencies, therefore, requires more than a mere facade of state involvement, for it is necessary in light of Parker's, that's another case, rationale to ensure the states accept political accountability for anti-competitive conduct they permit and control. So it states that active supervision means the inquiry regarding active supervision is flexible and context dependent. Active supervision need not entail day-to-day involvement in an agency's operations or micromanagement of its every decision. Rather, the question is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state's policy rather than the party's individual interest. So in response to this, the state legislature passed TCA 4-4126, which establishes supervising officials. So a supervising official is a commissioner or chief executive officer of the administrative department under which the regulatory board operates or to which the board is administrative attached, or the commissioners or officers designee. So the role of the supervising official is each supervising official shall ensure that the actions of the regulatory boards that displace competition are consistent with a clearly articulated state policy. Other than rulemaking, the supervising official shall evaluate whether the action may constitute a potentially unreasonable restraint on trade that requires further review. If it is determined that an action requires further review, this is what happens. You provide notice to the board within 10 business days that the action is subject to further review. Review the full evidentiary record regarding the action and conduct a review of the substance of the action de novo and on the merits. In writing, either 1, approve the action, 2, remand the action, or 3, veto the action. So if in review, I have a policy director that views all of our meetings. If there is something that occurs in the meeting that she may view as potentially an issue or non-competitive, that will come back to me, and we'll discuss it for further context. And then if something were to happen, we have 10 days to notify you, and at the very worst, that action could be vetoed by the commissioner. So that means basically, we just want to make sure that our commissioners are acting within what is outlined in your statute. So any actions that are considered outside of that may cause some kind of issues. But I don't think that is a problem that happens very often. But in case it does, we've got safety guard mechanisms that will be there as a corrective measure. So that is all I have for the Public Meetings Act and the Open Records Act. And I already mentioned the conflicts of interest thing. Does anyone have any questions for me in general?
No, I don't have any questions, but I think a lot of what we did through the task force was in direct response to that case in North Carolina to try to make sure there was no competition prohibition with our rules, our laws. It made it kind of an ease of entry into the business and promote more competition within the industry.
Right, so we don't want to do anything that is considered a restraint on entry into the industry. So we want this commission, I don't foresee any issues with that happening, especially with the statute changes or rule changes. But if we were, for example, on the legal report, we make recommendations. Obviously, those are just recommendations for you to decide. But if there is an instance in whether I believe that for some reason, or you may disagree and wish to institute some kind of other disciplinary action, if I find that that action may be a little bit shaky, I'll let you know, and then we'll just talk it out and try and come up with a better solution. So I'm always here for questions and for any kind of guidance you may need. And I'll always try to make sure that anything that we do within our meeting won't get us into any kind of danger with our Public Meetings Act, Open Records Act, or conflict of interest, or go to a front in against North Carolina Dental. So I just ask that you trust me with the advice that I give you. You don't always have to agree, obviously not. But if I tell you something like, hey, you really might not want to do that, I actually really mean that for you. But yeah, that's all of my talking. I've done far more than I ever intended today. But
Well, you're doing a good job, Anna. Thank you so much.
For your listening, and I will send this to Glenn directly after, so you'll have this in written format in case something I missed, or if you just really want to read the footnotes too. that'll be there for you.
John, you've committed it to memory, haven't you?
Yeah, I have. We appreciate you, and don't quit on us. You know.
I won't.
Don't say you won't. All right. Anything else under legislative updates?
Nope, that's all.
If not, we'll move on to new business. David, do you have something?
Why don't you come up to the microphone, David, and introduce yourself? Oh, there you go.
David Allen, Auctioneer, Music City Auction. I did want to pull up the statute, the amendment. So you had asked what specifically the statute said, and it says the following about online. There's two ways they addressed it in the Tennessee Code, annotated with the amendments. Let me pull it up. Auction means a sales transaction conducted by oral, written, or electronic exchange between an auctioneer and members of the audience, consisting of a series of invitations by the auctioneer for offers to members of the audience to purchase goods or real estate, culminating in the acceptance by the auctioneer of the highest or most favorable offer made by a member of the participating audience. So on the one hand, they included the word electronic. So now online auctions are now under your all's jurisdiction. But secondly, they also made the point of defining a timed listing, which would now address the 2006 eBay law, because that's where the loophole existed, because extended time listings were being included in quote-unquote time listing. And it says time listing means offering goods for sale with a fixed ending time and date that does not extend based on bidding activity. So that theoretically puts a clamp down on what is considered an online auction that is under your all's jurisdiction. And that's the actual bill itself. The second thing I was going to say, and it's in relation to when you all meet in August, I think one of the things that the auction community, and I'm not speaking for the auction community in the whole, I just know that this is what I'm getting from the people, is when you all start to do it, when you all start to make the rules and regulations, or they start to recommend rules and regulations, one of the biggest things is what are we going to do with the people who are in that gray area? For instance, I have 2 apprentices right now. So if the law goes into effect on July 1st, does an apprentice only have to be with me for 6 months? And if they have already been with me for 6 months, what other criteria do they have to meet in order for them to be considered an affiliate auctioneer and not under the regulations of having additional requirements put upon them? So that would be that seems to be the biggest challenge for not only this group, but you all too, is to see how are we going to grandfather in the people who are in this transition period. And I just want to say that seems to be the overriding concern, because I know I have people who are waiting for this July 1st law to come into effect before they decide they want to become auctioneers. And so, you got a year.
Well, the intent of the task force was that it would be immediately, and so if you were already an apprentice or now an affiliate auctioneer, that had you been there 6 months, you would qualify under the 6 month rule, and that would be, And also, we're phasing out the firm and gallery license, but the guy that has the gallery license gets to keep their gallery license. There just won't be any new ones issued,
right,
based on what the intent of the task force was.
Right. That's all I had. I just I knew you had said what was the actual language, and then that gray area of people who are in the limbo at this point. So.
All right, thank you, David. Any other new business?
Mr. Chairman, the only thing I want to bring up,
All right.
Here's where I'm a bit fuzzy, and I want the commission to think about this, and maybe I can get some help from the staff. If you're an auctioneer and you're licensed as an auctioneer, I know there's the exemption for this time listing for online auctions of personal property or real estate or whatever. But if let's say you're not an auctioneer and you're doing online auctions with a fixed time listing, no extensions, you're exempt, okay? But what if you're already an auctioneer and you're doing that too? Are you not covered? Are you not covered by that law anyway? I mean, you can't say I'm an auctioneer and I'm doing licensed activity over here, but now I'm doing things that you don't cover over here. That doesn't make sense to me. That if you're a licensed auctioneer, you ought to abide by all the rules, not just the rules that apply only to auctioneers.
I believe that if you're already an auctioneer and you're doing that kind of activity, that you would still be governed by the auctioneer laws and statutes. I don't think you can do license activity because at the end of the day, you're licensed.
I know of a particular case where there's an auctioneer who is trying to skirt being regulated on the number of sales they do, and they're saying, well, that's not covered because it's a fixed time listing. Well, if you're a licensed auctioneer, you ought to be covered by all the rules, and that includes how many vehicles you sell, how you sell them. I don't see how you can do both.
So I'm going to defer answering that question until I get the full statute and the full reading, and then I hope I can have an answer for you at the August meeting. I just want to see how everything is worded in the final bill in order to answer that best to your ability.
You know where I'm going with this.
Yes, I understand.
Anything else to be brought up in the new business? And a motion we adjourn.
So move.
Motion's been made and seconded. All in favor say aye.
Aye.
Any opposed? Stay here.
Thank you, sir.